Thank you, Flora. I'm going to briefly talk to you today about human rights damages and wrongful dismissal cases, and then we'll have a quick break so you can fill up your coffee mugs and grab something to eat. So first I'm going to discuss about what human rights damages are, and we'll discuss a recent and important change in the law. Next I will go over some recent case law, court decisions specifically, and I will discuss implications of the recent law change and what you as employers and human resources professionals should know. So human rights damages arise out of violations of the Ontario Human Rights Code. In the employment setting, these violations include discrimination in the workplace because of one or more of the protected grounds, with which I'm sure you're all aware of, but they include race, gender, age, marital status, family status, and disability. So prior to 2008, courts did not have the authority to award damages for breach of the Human Rights Code. So previously, if an employee wanted to claim wrongful dismissal and at the same time felt that he or she was discriminated against, the employee would have to commence a wrongful dismissal lawsuit in court and then a separate application under the code. However, in June 2008, the Ontario Human Rights Code was amended to include section 46.1, which expressly allows the court now to order remedies for human rights violations. So section 46.1 of the code provides that in a civil proceeding in court, the court may make either one or both of the following orders. Number one, an order directing the party who infringed the right to pay monetary compensation to the party whose right was infringed for loss or injury arising out of the infringement, including compensation for injury due to dignity, feelings, and self-respect. The second order they may make is an order directing the party who infringed the right to make what they call restitution other than monetary compensation for the loss arising out of the infringement, including restitution for injury to dignity, feelings, and self-respect. This section was designed to create efficiency and avoid multiplicity of proceedings. So while it does not give a former employee the right to commence a civil action based solely on a human rights violation, essentially they are now able to have discrimination claims piggyback wrongful dismissal claims in court. So in sum, if the employee only has a human rights claim, typically they go to the Human Rights Tribunal, where they have a wrongful dismissal claim as well as a human rights claim. I would suggest going to the court. Makes it easier. You have one route instead of going to the court and the tribunal. And if you only have a wrongful dismissal claim, you would seek the remedy from court, as a tribunal does not have the authority to deal with wrongful dismissal claims. So there are some differences in pursuing claims with the Human Rights Tribunal as opposed to proceeding in courts. Two important differences that I'm going to highlight for you today are, one is that the tribunal has actually used its power to order reinstatement of employment. So essentially the tribunal can say, you know what, this employee gets his or her job back. Whereas in court right now, it's unclear whether a court would actually order this. Section 46.1, which I just discussed, appears to give the court the power to order a reinstatement, but to date there have not been any reported decisions utilizing this power thus far. And the second point I want to make here is that as the law stands right now, the tribunal has no authority to award costs for legal fees. As such, applicants are able to pursue claims without having to consider the possibility of having to pay any portion of the other party's legal fees in the event that they are unsuccessful. However, the law might be changing in this area. In December 2013, Bill 147, which is a Human Rights Code Amendment Act awarding of costs, passed the first reading in the Ontario Legislature. if it enacted into law, this bill would amend the code to empower the tribunal to award costs against a party, as well as costs in favor of a party. However, this bill is still in the early stage of the legislative process, and we will kind of have to wait and see whether this will become law. So the first case I'm going to talk to you today is Wilson and Solin Mexican Foods. It's a 2013 Ontario Superior Court decision. This was the first court decision made since the amendment of the code in 2008. So it took about 5 years for the court to make a decision on this. The facts of this case were that the employee was employed for 16 and a half months. She originally started as an assistant controller and then worked as a business analyst. She was 54 years old and earning $65,000 a year. While she was on leave for absence of a temporary back problem, the employee terminated her employment, citing organizational changes as the reason. The employee commenced an action in court for a wrongful dismissal, and in addition claimed she was terminated in part due to her chronic back problem. So the employee advised her employer of her back problem in around December 2010, and she had taken a leave of absence. During her leave, the employer had requested medical documentation, and when the employee provided her employer with a doctor's note indicated that she could return to work on a gradual basis, the employer said that was not acceptable. They wanted her to return to work full-time with full-time duties. The last communication from the employee's doctor was delivered about 3 weeks before she was fired and indicated that the employee would be required to be off work for another 6 weeks. In the result, the employer terminated the employee's employment and was given 2 weeks' pay in lieu of notice. The judge in this case found that the employer violated the employee's human rights under the code and that the employee's back problem was a significant factor in her termination. The judge stated that a decision to terminate an employee based in whole or in part on the fact that an employee has a disability is discriminatory and contrary to the code. In coming to this decision, the court relied upon the proposition that employees are under a duty to act fairly and are required to be candid, reasonable, honest, and forthright when dismissing their employees. In considering the appropriate award for damages, the court considered the employee's loss of her right to be free from discrimination and the fact that she experienced victimization. An aggravating factor that the court also considered was the employee's behavior, and specifically that the employer had orchestrated the dismissal and was disingenuous at various times both before and during the termination. For example, the employer said that the employee was dismissed due to organizational changes when in reality they dismissed her because of her back problem. It's important to note here that the only evidence that the judge had with respect to the employee's injury to feelings, dignity, and self-respect was limited to 2 statements in her evidence, specifically saying that she was shocked, dismayed, and angered by the employer's pre-termination letter, and also a vague reference to her loss of dignity and loss of feelings of self-worth in relation to that same letter. No other evidence with respect to the employee's injuries was given. Nonetheless, the court awarded 3 months' pay in lieu of notice, plus an additional $20,000 in general human rights damages, representing about 30% of her annual salary. The employee was also awarded legal costs, a remedy, as you know, would not have been available had she pursued her claim through the tribunal. In its analysis, the court here adopted the same principles that the tribunal has established over the years in dealing with claims of discrimination. This next case I'm going to talk to you about is Berkhout and Numbered Company. It's a 2013 Ontario Small Claims Court decision. Here, the employee was employed for only 4 months when she was terminated after complaining about sexual harassment at work. The deputy judge here held that employment had been terminated because she complained of the sexual harassment and awarded damages for unlawful dismissal and awarded her damages in the amount of $15,000 for violation of her human rights. This decision was originally appealed. The employer appealed the decision, but I found out that both parties agreed to consent to dismiss the appeal. So that law stands. Now, the last 2 cases I talked to were court decisions. I'm going to talk to you today about Fair and Hamilton Wentworth District School Board. I bring this to your attention here as it highlights the risks employers face when terminating employees on disability. The employee here worked as an environmental supervisor, and she developed a generalized anxiety disorder that prevented her from performing her duties. She was terminated from employment after returning from her disability leave. The employer in this case claimed that there were no other positions available to accommodate the employee after she returned from leave, and the employee claimed discrimination on the basis of disability. The tribunal here held that the employer had discriminated against the employee on the basis of disability by failing to accommodate her. The tribunal also ruled that the employer violated the code and ordered reinstatement of her employment through alternate positions. They also awarded her damages for all lost income dating back 9 years, plus declaratory relief related to her pension and seniority. So in numbers, the employee was awarded $30,000 in general damages for her injury to her dignity, feelings, and self-respect. And this is a significant point here, is that the employee was also awarded $420,000 for back wages dating back 9 years, which is the largest award for wage loss in Canadian human rights litigation history. So this, I don't know why, but this took 9 years to resolve. And that's what happens when it takes 9 years. So not only do you have to pay her that, you also have to employ her. So what should you take from all this? Well, a review of the tribunal decision suggests that current damage awards are in the range of about $500,000 to $15,000 are typically being awarded, with exceptional damage awards around the range of $25,000 to $45,000. And this higher range is in serious cases that involve sexual discrimination or termination of employment. As we saw in the Wilson case earlier, the court will look to tribunal decisions for guidance. So I would expect that these ranges here, the court will also follow. The tribunal has acknowledged that damage awards are too low, and they are appearing to trivialize the social importance of the code by essentially creating a license fee to discriminate. Low damage awards also suggest that your human rights are not important. You know, if you're spending $10,000 to go to the tribunal and you get an award of $1,000, you know, really what's the point? As such, there has been a push in recent years to have these awards increase to make it actually worthwhile for people who have valid human rights claims. And though I do note that a significant increase hasn't actually happened yet, I would expect in the future to see damage awards on the rise. So what do you take from all this today? Employers should use extra caution in any decision to terminate an employee when there is an issue with respect to human rights claims. Specifically, which I find a common one, is when an employee is suffering from an illness or disability and is on leave. A disability cannot be considered a factor in deciding whether or not to terminate one's employment, and now there is a risk that a court can order reinstatement and having to pay back wages to that employee. Again, the case law is still developing in this area, so So we're not really sure where it's going to go from here. And that last point I want to make is, as now that human rights claims can be coupled with wrongful dismissal claims, it makes it easier for employees to make these claims, and as such, employers should expect to see an increase in these kind of claims upon termination and higher dollar amounts claimed when they do go to court. Thank you very much, and now we're going to have a little brief break, 15 minutes or so.